Ladies and gentlemen, that's the moment to to kick off this session, really. Before that, I have to make a certain precision regarding Zoom, because I talked about your access to the courses on Zoom. So you don't have access to the courses on Zoom live because you're here. But if you are sick, you must stay home. You can ask to have an access. So that's the way it goes. But then when you're back home, you can look back the courses on the platform Vimeo for 3 weeks, beginning the day after the course. Okay, so I will now welcome warmly Professor Maarit Jänterä-Jareborg, whom I met when I was elected as a Secretary General of the Hague Academy, because she was a member of the Curatorium at the time. So she will tell you more. But I'm very happy to meet her back here for this opening lecture. Let me present very briefly Professor Jänterä-Jareborg. She's Professor of Private International Law and International Civil Procedure at Uppsala University in Sweden since 1998. And she's honorary doctor of 3 other universities. She defended her own doctoral thesis in private international law at Uppsala University in 1989. She has served as delegate to the Hague Conference of Private International Law and as a member of European Union working parties. She's an elected member of several scientific academies in Sweden and abroad, and her CV includes many prizes and awards for her research in private international law, international civil procedure, comparative family law and religion. She was a member of the Curatorium of the Academy, as I said, from 2005 until 2017. In 2014, she acted as the Director of Studies of the Hague Academy Center of Research in the topic Women's Human Rights and the Elimination of Discrimination. A must read, I must say, and you can find it in the library of the Academy. Thank you very much, Maarit, to be here again and to deliver this very much expected lecture on human rights in a world in transition, the challenges of private international law. Since I took 4 minutes to you, you can grab 4 minutes after the ding dong to finish your lecture. Thank you.
Thank you, Jean-Marc, and thank you in particular for the 4 extra minutes. Ladies and gentlemen, dear colleagues, and in particular, young international lawyers from the whole world. It is a great honor for me to meet you all here and to deliver this inaugural lecture, especially now that it's the 100th anniversary of the Hague Academy. I have been to the Academy since 1979, 44 years ago, as a student. And then I have come back in numerous different capacities, first as a director of studies, then as a lecturer or professor, then as the director of the Studies Center. And in between, I have been also a member of the Curatorium. To come to The Hague has always been a wonderful and very special experience to me. And I hope you will feel the same way, and during all the decades to come, you will want to come to The Hague and enjoy all the learning in this city, but also its magnificent culture, its restaurants, and whatever. My lecture is about women's rights in interpersonal cross-border relationships. My topic is also about men and for men, the other half of humanity. As the United Nations Agenda for Sustainable Development Goals 2030 points out, any discussion on women's rights and empowerment concerns men and men's engagement in these issues is a necessity. My focus will be on the regulations and case law of private international law in respect of their general development in the 20th and 21st centuries, and as impacted by the growing global migration and people moving and building families across national borders. The potential for conflict increases the bigger the differences are between the country of origin and the country of destination in terms of culture, traditions, and other norms. The secular legal system of the country of destination might grant little, if any, scope for customary or faith-based rules of the legal system of the country of origin. The country of origin might, in turn, totally disregard that secular system's standpoints. This produces limping family status and limping rights and duties, valid in one state but not in another, and exposes the concerned persons to enormous difficulties of legal, practical, and emotional nature. Families across borders consist not only people fleeing from tyranny, persecution, or poverty, or people leaving their country of origin for better future and educational opportunities. Included are those with rich human capital, or who for some reason or other leave their country of origin, and those who marry or enter into de facto unions across borders due to love or affection. Many of you are probably already involved, as I am. At Uppsala University, my home university, the emphasis in the first lecture delivered in the discipline of private international law is always the following. As a lawyer, you should never at the outset nationalize a legal relationship by automatically applying a state's domestic substantive law. Always observe, for the sake of justice and respect for the rule of law, if in the situation of the parties, factors of connection exist or have existed to another country. This is increasingly the case, often in a hidden manner, and may have considerable legal implications through the rules of private international law. Private international law is commonly described to be about localization of cross-border situations. It regulates issues of the determination of jurisdiction, applicable law, and recognition of foreign judgments and other decisions. The questions that arise are primarily the following. What grounds justify a national court or other judicial authority to exercise jurisdiction in a cross-border case? Which involved state's law should be applied? Can a judgment or other decision, including acquisition of a family law status, qualify for recognition and legal effects in another state's jurisdiction? The fourth issue is judicial and administrative cooperation across state borders. These questions may appear technical to outsiders, but their determination will be decisive for the outcome in any cross-border issue. The world is in transition. I believe we all agree on that. There is a lot of global tension. We have recently testified revolutions and civil wars within states and are witnessing armed conflicts between states. Sexual violence against women and girls continues to be a method of warfaring. Humanity faces the consequences of climate change and the risks of impaired living conditions, and particularly for the future generations. The UN Agenda on Sustainable Development Goals 2030 refers to billions of citizens who continue to live in poverty and are denied a life of dignity, and the enormous disparities of opportunity, wealth, and power. And in all this mess, gender equality remains one of the key challenges. More or less around the globe, the assumption exists that treating men and women differently does not amount to discrimination. Thought-provokingly, a recent global study indicated that 73% of the world's current population did not regard women's equal rights with men as relevant to democracy. 25% considered that corporal punishment of wives could be justifiable. The right to equal rights and prohibition of discrimination in the enjoyment of these rights are at the core of the United Nations General Human Rights Instruments and apply also under the regional human rights documents. In 1979, the Convention on the Rights of Women and the Elimination of All Discrimination Against Women was adopted within the framework of the United Nations, the so-called CEDAW Convention, or the Convention on Women's Rights. This convention obliges states to take all appropriate measures, including legislation, to modify and abolish existing regulations and customs and practices which constitute discrimination against women. A specific provision in this convention addresses women's rights and their role within marriage and the family. This convention is the second most ratified UN convention after the United Nations Convention on the Rights of the Child. This is, of course, very positive. But what is the convention's real impact in life? In 2018, a working group set up by the UN Human Rights Council raised concerns of alarms. All around the globe, movements were opposing the universality of women's rights. The group reported that the concept of gender is challenged, I quote, misunderstood and misused. And concepts such as complementarity, equity, and protection of the family are used to weaken women's rights. The group emphasized that while the principle of freedom of religion or belief as a human right must be upheld and protected, it is unacceptable to use religion to justify discrimination against women. The group had witnessed the resurgence of a very conservative and retrogressive narrative in international forums and at a national level, and attempts to reinstate policies and legislation that are harmful to women. So why has the CEDAW Convention failed its global goals? One reason is that many states, upon ratification of the convention, entered reservations against specific provisions, most notably those dealing with women's place in the family, even if this is in violation of the convention's object and purpose, and thus not permitted under the Vienna Convention on the Law of Treaties. In comparative law research, it is common to refer to the cultural constraints of family law. Theories such as the multi-layered nature of law and deep-level comparative law contribute to answers. Simplified, the goals and standards of the Women's Rights Convention are not in agreement with the fundamental basic levels of many states, societies, or legal systems. Now, due to my own background with my nationality of origin in Finland and my nationality of destination in Sweden, my perspective will be primarily Western and in particular continental and Nordic European. All of them states within the primarily legislative civil law tradition. It is estimated that there were around 281 million international migrants in the world in 2020. This equates to 3.6% of the global population. Overall, the number of international migrants has increased over the past 5 decades. The recent migration waves to Europe have triggered restrictions, not only in the receiving state's migration law, but also in their private international law, with less openness towards the foreign. The motive given is to promote integration, human rights, and the need to signal what the state regards as harmful practices. Parallel, other developments have called for change in the spirit of modernizing the rules to fit the needs of contemporary European societies. In the continental European systems, in matters of the family, habitual residence has replaced nationality as the primary connecting factor. The modern choice of law rules are drafted in a gender-neutral manner. More scope is furthermore given to the parties' own preferences through the introduction of party autonomy, giving the parties the freedom to agree on the application of a closely connected state's law. Some rules are result-oriented, for example, when the law applicable is determined on the basis of fairness with regard to the interests of a party presumed to be in need of protection. The otherwise applicable law can also be set aside when it treats the parties differently on the basis of their sexes. Universal application applies, meaning that the rule's applicability in the state of the forum applies in relation to all states. I assume that the so-called public-private divide and the dualistic and monistic approaches to what qualifies as international law will be discussed in the forthcoming seminars. It is an engaging and continuously topical issue. The dualistic theory draws a sharp line between a public international law and a private international law. Only public international law can qualify as international law. The monistic theory takes a holistic approach in which both public and private international law can coexist as two different branches of international law, but with much in common. As international jurists, you might find this outlook more appealing. Indeed, today, and more stronger than ever, numerous reasons speak in favor of accepting and promoting a more monistic approach. I will name some of the more important ones of them. In substance, human rights instruments cover cross-border relations between private parties. In several states, a trend goes towards rules reflecting internationally accepted principles. A bulk of the private international law regulations originates from states' treaty obligations, such as conventions adopted at the Hague Conference of Private International Law. And even when states do not wish to subscribe to the convention as a whole, as a colleague says it, they tend to take account of them in shaping their own rules. The profile and mission of the Hague Conference of Private International Law, that is the discipline's leading actor, strives today to be global and in line with the goals of universality and inclusiveness. Decisions are based on consensus to the largest extent possible. More than 90 states from all continents are members of the conference. The European Union uses regulations of private international law today as a tool for the achievement of a common European judicial space and to promote citizens' free movement within the Union. In application, these rules cover all persons habitually resident in a European Union member state, that is even third state nationals. These rules are largely modeled on Hague Conventions on corresponding topics and take account of the work at the Hague Conference. In personal and family law matters, the preambles to the regulations explicitly state that the regulation respects fundamental rights and observes the principles recognized by the Charter of Fundamental Rights of the European Union. And certain specific fundamental rights may be pinpointed, such as non-discrimination on the basis of a person's sex. Through their jurisprudence, transnational human rights courts continuously develop and extend the scope of human rights, often through evolutionary interpretations, and in this manner reduce the contracting state's margin of appreciation. These rulings' impact extends to private international law. The explicit acknowledgement of a human rights dimension in private international law is a relatively new development, but with a lot of potential in terms of harmonization. It forces us to reconsider the previously widely established vision of private international law as a system of neutral rules, a discipline that stands over substantive values. My original plan when preparing this lecture was to analyze the contemporary European rules on certain family law issues in the light of the equality standards of the Women's Rights Convention, namely formal and substantive equality, the latter focusing on the reality of the parties' situation. However, in this exercise, the traditional and much debated distinction between a so-called private international law justice and a so-called material substantive law justice continued to pop up. Until recently, it was common practice to recognize foreign marriages when validly concluded in the state of celebration. In the spirit of favoring validity, many states' private international law also provided for recognition if the marriage was regarded valid under the spouse's personal laws. This position is endorsed by the 1978 Hague Convention on the celebration and recognition of the validity of marriages, which has provided a source for inspiration in many, many states. These rules are gender neutral and are in accordance with the formal equality of the spouses or spouses-to-be. This recognition-friendly stance has recently been reconsidered in many Western states of destination through the introduction of specific grounds for providing for refused recognition. Underage marriages are the primary target. In the Nordic states of Europe, 18 years is more or less an absolute age requirement, whereas in Germany, 16 years of age may suffice in cross-border cases. Forced marriages and marriages by proxy are another focus. Polygamous marriages are refused recognition as contradictory to the monogamous nature of a marriage. In some states, the marriage is refused recognition if at least one of the parties at the time of the marriage was habitually resident or a national of the state where recognition is sought. In some other states, non-recognition is more absolute and not dependent on any such link. The passage of time does not remedy the original defect, such as when the underage spouse reaches the age of maturity or when common children are born. Logically, refused recognition means that no marriage exists and no rights and duties attached to a marriage are available. Exceptions might be available, but a high threshold applies, as illustrated by a precedent from Sweden's Supreme Administrative Court. In this case, a girl habitually resident in Sweden had validly married in Palestine at the age of 17 years, 11 months, and 20 days. Her application for the registration of her marriage in Sweden was refused. In the court's opinion, the girl's pregnancy and the fact that the marriage had been concluded only 10 days before her 18th birthday did not qualify as special reasons to recognize the marriage. In this case, the young couple wished to establish their marital home and joint residence in Sweden. Now, at the outset, one might, of course, think, why don't the parties opt for a new, valid marriage ceremony once both are of age? For the spouses, faith and cultural objections may, however, create an obstacle. The Muslim rules they follow in their personal lives or the rules in their country of origin may forbid their remarrying each other unless they have first divorced, then remarried a third party, followed by a divorce in that marriage. From the Swedish legislator's point of view, this is no big issue, having regard to the couple's continued right to private life as cohabiting partners. True enough, human rights instruments, including the Women's Rights Convention and the 1978 Hague Convention, condemn the practice of child marriages, but do not specify an age limit. In fact, international human rights bodies report on an increase of underage marriages. Considering that the law reforms in the states of destinations strive to prevent exploitation of a vulnerable person, usually the wife, the test of substantive equality could be considered fulfilled. Or it cannot be ignored that the rules on recognition deal with situations where a marriage has already been concluded and the marital life of the couple established. There is reason to expect that non-recognition affects the wife and the common children in particular. In that case, the CEDAW Convention's substantive equality requirement is not fulfilled. More than so, we are dealing with a human rights violation, that of the right to protected family life. Recently, the German Federal Constitutional Court delivered a ruling of principled relevance. In 2017, a provision was inserted into Germany's private international law legislation invalidating validly concluded foreign marriages in case one of the parties at the time of the marriage was under 16 years of age. The German Constitutional Court found this reform legitimate as such, with the goal of prevention and proscription of child marriages worldwide. However, in the court's opinion, the reform is not proportionate because it does not provide for any consequence from the relationship formed lawfully under the respective law and being still a subsisting marital community. The German reform does not either provide for transformation into a valid marriage after the time the minor attains maturity and wants to be still married or stay in this relationship. In conclusion, the German Constitutional Court considered that a violation of the German Constitution had taken place and expects now new law to come into force, remedying these effects by June 2024. In my opinion, this is a balanced ruling and in line with the requirements of substantive equality. For a migrant couple to have access to divorce in the country of destination, their marriage must be recognized. And even so, there are other difficulties. Again, I refer to a Swedish case now from a court of appeal. A married Bangladesh couple with children had resided in Sweden during 4 years, but without a residence permit. An order for their expulsion was issued. The wife initiated divorce proceedings in Sweden, but the husband opposed to the claim. In support of his refusal, he referred to the legal system of Bangladesh, where the personal law of Hindi spouses did not permit a divorce. The wife and children were placed in a sheltered accommodation in Sweden, and the husband, who had been sentenced for violence against the wife, was banned from contact with them. The court granted divorce with regard to the circumstances of the case. Under Sweden's own rules of divorce jurisdiction, a Swedish court may exercise jurisdiction if the plaintiff's request cannot be tried in his or her foreign country of citizenship or habitual residence. Given that one of the spouses objected to the divorce and that none of them was a Swedish national or habitually resident in Sweden, Bangladeshi law would exceptionally have been applicable under the Swedish, even current choice of law rules. The court found special reasons to apply Swedish substantive divorce law, namely the children's best interests. As long as the marriage continued, the spouses shared custody rights, and the deep conflict between them threatened the children. And now, importantly, the fact that the spouses risked expulsion to Bangladesh and that the Swedish divorce would not be recognized there were, in the court's opinion, not sufficient reasons not to grant the divorce under Swedish law. In my opinion, this judgment fulfills the standards of both formal and substantive equality. It corrects the lack of them in the other concerned states' law. In the case at hand, the European Union's regulation on the law applicable to marriage dissolution would have resulted in the same outcome, and in fact in a more straightforward manner. If, namely, the referred law, in this case the law of the spouse's common nationality, does not provide for divorce or does not grant both spouses equal access to divorce on the grounds of their sex, then the law of the court ceased shall apply. Until recently, spouses' marital property relations were in many states subject to the law where the husband at the time of the marriage was a citizen. A corresponding rule in some other states fixed the spousal property rights to the law of the state where the husband was domiciled at the time of the marriage. How could democratic Western states justify the continued application of a rule which appears to scream formal inequality between spouses? Successively, constitutional courts in several European states were confronted with the constitutionality of rules linking the applicable law to the husband. The rules were found to violate against the state's constitution. The rules' replacement took time, however. For example, Germany introduced its law reform in 1986 and Italy in 1995. In Sweden, the above-mentioned choice of law rule was replaced in 1990, in Finland in 2002, and in Denmark as late as in 2019. All the later law reforms advocate connecting factors which are common to both spouses. They also provide for party autonomy, enabling the spouses or future spouses to designate a law to which at least either one of them is linked through habitual residence or nationality. In the majority of the European Union member states, the national rules, even the new ones, are now replaced by the EU's regulation of matrimonial property relations, in force as of 2019. In case the spouses have not made a choice of law agreement, the law which became applicable at the time of the marriage continues to apply all through the marriage. This might be considered surprising in a union which strives to promote integration. However, the EU justifies it with reference to predictability, legal certainty, and the spouse's expectations. No empirical studies exist, however, what spouses actually expect, while, of course, each of them in a dispute wishes to come out as the winner. Among my mails, I found the following. Dear Maarit, I have read many interviews with you on custody disputes in international situations. I live in Sweden since many years back, but I have never felt at home here, culturally or socially. I feel like a prisoner who has not achieved anything. I miss my parents, siblings, and friends, and my home country, where I might have a career of my own. I am separated from my Swedish husband, and we are going to divorce. I wish then to move back to my country of origin, which is another member state of the European Union, together with our 2 children, who are 2 and 5 years of age. My husband refuses to consent to this. The lawyers I have consulted inform me that without his permission, the husband's permission, I cannot take the children with me. We have joint custody rights. The children are born in Sweden and grown up here, but have my and their father's nationality. They are well acquainted with my original family environment and all the family there. The older one speaks my native language. These lawyers seem to understand nothing, or am I wrong? Please help me. The mother had received the correct advice from her lawyers. The children's habitual residence is undoubtedly, under the circumstances, in Sweden. And Swedish courts alone have jurisdiction to decide on issues of parental responsibility. In this case, particularly custody of the children, access rights, and their future residence. This is the position taken both, I still have some time. This is the position taken both by the European Union, so-called Brussels II regulation, and the 1996 Hague Convention on Parental Responsibility. It is also the position of the 1980 Hague Convention on International Child Abduction. And the conflict of law rules refer in this case to Swedish substantive law as the law of the children's habitual residence. So when a national court decides on a case like this, it should be the child's best interest that are in the center, and whenever possible, hearing the child in a suitable manner. So, the Hague Child Abduction Convention from 1980 is by now ratified by 102 states around the world, the most successful of the Hague Conventions ever. Still, problems exist. The ideology is to prevent international child abduction, and when such has taken place, to return the child as quickly as possible to the contracting state of its habitual residence. But there are problems. It was estimated in the beginning that fathers would be the abducting parents in most cases. In fact, in reality, it was the mothers who are also the primary carers of the children. The latest statistics that I know about on the application of the Hague Convention worldwide are from 2015 in a study carried out by Professor Nigel Lowe and Victoria Stevens. That year, 2015, 73% of the taking persons were mothers, 24% were fathers, and the remaining 3% comprised grandparents, institutions, or other relatives. And 91% of the abducting mothers were the primary caretakers. Now, when child abduction across borders becomes immensely difficult, this is again when the two concerned states have very different outlooks on the best interests of the child. And this applies in particular when in the one state the parents enjoy equal rights and duties as custodial parents and guardians, which is the standard required by the CEDAW Convention, and in the other state, a gendered parental responsibility notion applies. That means that fathers and mothers have different capacities as holders of parental responsibilities, and the child's age and sex is also of relevance in this context. After a divorce, a mother who is not of the faith required cannot acquire custody rights. The same applies if the mother remarries or if she does not continue to live near the child's father, the guardian. And all these restrictions may, as said, be interpreted to be in the child's best interest by ensuring that he is supervised, the child is supervised by his legal or her legal guardian, is raised in the right faith, and is not made to live in the household of a stepfather. It is now time for me to sum up. So, how do women fare in a world in transition? My answer is with risks and not sufficiently well. This state of arts does not in itself constitute discrimination, and exceptions exist where everything might work to the woman's advantage. Admittedly, there is no such concept as the principle of the best interests of women, And admittedly, such a principle in itself would be in contradiction with women's and men's right to enjoy equal rights. In fact, rules based on purely national values are today clearly inadequate. Considering that legal practitioners, national courts, and not least parliament members usually lack deeper insights on international law, including human rights instruments and private international law, active engaged by legal scholars can provide the successful tool against national rulings and legislation based on the short-sighted current populistic trends and policies. Dear young lawyers of international law, a mission of life lies ahead of you. Thank you.